court is going to be working through notes, so this may be a little bit disjointed. I'm going to ask that you folks bear with me. Court is prepared to rule. Mr. Green, in his LUPA petition, as the court understands it, alleges that he had standing because he was the applicant for the decision in SPR 24121. That's what he alleged. And his challenges to the decision that's attached to the petition, he alleged essentially all sorts of challenges about hearing examiners erring in concluding that various features about the project were adequate. Specifically, he alleged in paragraph 4.8.9 that the transportation services were adequate. And he alleged in the legal conclusion paragraph implications regarding the invalidity or the effect of the ZCI at paragraph 4.8.16. In its motion to dismiss, the county says Mr. Green was not the appellant under SPR 2421. He was the appellant under SPR 18821, which is the appeal of the approval of the type 2 application regarding the project. That he is not, does not have, in fact, have standing under LUPA on this petition as the petitioner in 24121, and that he was an appellant at an earlier phase in the permitting process in these proceedings, and that his petition should be dismissed. Mr. Green comes back and says, I do too have standing, even though I am not, in fact, the appellant in the specific decision that we are appealing. And he cites showing to meet the test that he has standing, he cites the summary of his testimony as it appears in the hearing examiner's decision in the appeal from the type 2 decision, and he submits his own declaration stating the facts that he believes gives him standing to pursue this LUPA petition. As the court referred to in argument, it is the policy of the law that disputes be decided on their merits. Yes, he has to demonstrate standing, but it exalts form over substance not to consider the facts that he is asserting, it both in the testimony that was quoted and in his own declaration that he asked the court to consider to demonstrate that he has standing. And the court is in fact considering both of those sources, not just what's in the petition, in deciding on Island County's motion to dismiss. We start from the court's perspective with RCW 36.70.c. Mr. Green is not the applicant or the owner of the property on which the land use is directed. What he is or alleges to be is 3670C0602. He is a person who alleges that he's aggrieved or is adversely affected by the land use decision. To do that, all four of the subconditions must be met. That The land use has prejudiced or is likely to prejudice him, that his asserted interests are among those the local jurisdiction was required to consider. Judgment in favor substantially eliminates or redresses prejudice, and or that he has exhausted his administrative remedies to the extent required by law. So what do those things mean? Both parties, Island County cited Knight versus Yelm at some extent. Mr. Powell referred to it in his oral argument as it happens. The court also found it very helpful. Looking at numerated paragraph number 24, and not referencing any of the internal citations. And again, this is Knight, Knight versus City of Yelm, 173 Washington 2nd, 325, 2011 decision. To satisfy LUPA's prejudice requirement, a petitioner must show that he or she suffers an injury in fact as a result of the land use decision. He has to allege specific and perceptible harm. If he's alleging a threatened rather than an existing injury, he must also show that the injury will be immediate, concrete, and specific. A conjectural or hypothetical injury will not confer standing. A party need not show a particular level of injury in order to establish standing. Then we get the next paragraph, which is examples of parties who have standing, citing Suquamish tribes, 92 Washington Appeals at 8/29/30. The folks who had standing alleged that the proposed land use project was going to affect them by resulting in increased traffic. One member lived 150 feet from the project. Another lived on property that would be surrounded on 3 sides. Evidence that the members would be affected by the large predicted increase in traffic was sufficient to establish injury in fact. Then the next paragraph is the in contrast. Here are the cases that say you don't have standing. The interveners in Nykreim, and I'm going to spell it Nykreim, cited at an earlier point, 146 Washington 2nd at 934. They lacked standing because their sole interest was to preserve the protections of zoning in the district. Their interest in the case was merely the abstract interest of the general public in having others comply with the law. It is informed by that guidance as to what we're looking for that the court has assessed the specific information that Mr. Green has provided. Looking at page 5 of his response to the motion, providing the examiner's summary of his testimony in the appeal of type 2. He testified he moved to a rural area of Whidbey Island approximately 3 years ago so that he would have only a few sparse neighbors. Now, that appears to be inconsistent with the testimony or the declaration in the sense that the court did not read Mr. Green's own declaration to say that he had moved here, but rather that he owns property here. And I'm assuming that's one of those misunderstandings that happens when a hearing examiner is making notes and compiling testimony. Mr. Green noted that the appellant's project would impact the rural nature of the community by allowing it to bus people from Oak Harbor to the proposed location and back on a daily basis. He describes his experience working in the building trade and his familiarity with the codes. He identifies the legal issue about the review in phases that the hearing examiner ultimately agreed with, and adds also that he thinks that the church building's not designed for emergency use. From the court's perspective, that testimony is just the kind of generalized, hypothetical concerns that are real and authentic and that don't confer standing. Similarly, in his declaration, the concerns about quiet rural atmosphere, his fears that a homeless shelter is going to affect that, his belief that the urban infrastructure that's there is not suitable, that he worries, that's what he said, he worries that on-site wastewater treatment methods are insufficient, are again generalized concerns. They are real, they are authentic, they're fair, they're not sufficient to confer standing. In the court's judgment, Mr. Green's allegations about traffic and transportation are different. The specific allegations are that he owns property less than a mile from the site. He regularly uses Morris Road. He routinely travels through that intersection of Highway 20 and Morris Road, where the coalition's project is to be located. He says the turn onto Highway 20 is near a bus stop and near on a curve with limited sight lines. I think as a usual user, I have a specific interest. He notes also at paragraph 4, it's going to affect the functioning and will increase both pedestrian and vehicular traffic at the site. That's a useful place from the court's point of view before reaching the issue about his challenge on transportation to talk for a moment about the ZCI, because the ZCI is a type 2 decision, which means that under code number 1619-160B, excuse me, I've skipped one. Under 1619-140A1, notice for the type 2 decision, right? There's one of those big yellow signs that says there is something pending regarding a zone coding interpretation is going to be by publication and posting of the subject property. Every time Mr. Green drives by that property, he is going to see that yellow sign saying that there is this application pending. Notice of the decision under 1619-160B2. Any person who prior to the decision being issued, if you request in writing notice of the decision, they have to give it to you. It is not just the applicant who gets notice. Anybody gets notice, and by first-class mail, just like the applicant does. And as far as appeals, appeal of a type 2 decision, that's an administrative appeal, is filed with the hearing examiner. This is 16-19-190B1, can be by an applicant, by a department of the county, or any aggrieved person. We don't get to know whether Mr. Green's attempt at an appeal would have been accepted as by an aggrieved person. That's an appeal of the ZCI, because Mr. Green did not appeal. As regards the challenge to the ZCI, he has not exhausted his administrative remedies. That is out. Now, as regards his concerns about traffic congestion, and he specifically referenced in his testimony the part about the project's going to impact the rural community by allowing it to bus people from Oak Harbor to the proposed location and back. But Mr. Green is not challenging the hearing examiner's findings as regards how the shelter is actually going to be used. They are going to be screened at and then transferred from Oak Harbor at 6 p.m. each night and driven back to Oak Harbor each morning at 7 a.m. via vans operated by the applicant. The site is adjacent to State Route 20, which is a state highway. The patrons aren't going to be using the bus or the bus stop to get to or from the site. In this regard, the court went and looked at Suquamish Indian tribe, where traffic congestion was sufficient. There was evidence of a large predicted increase in traffic. One of the successful petitioners in establishing standing lived 150 feet from the property, who cited the environmental impact statement saying there's at least a 48% increase in traffic on the road that runs in front of his house. The guy whose property was bordered on 3 sides alleged that same increase for that same road. Third guy is saying he's going to be affected by the large predicted increase on 2 roads that provide the primary access to his home. The record is devoid of any facts suggesting concrete and specific impact of traffic in particular, which the court considered in detail. From the court's perspective, the court appreciates and understands that Mr. Green has concerns, but it is the court's responsibility at the initial hearing in a LUPA petition to determine, presented with a challenge to standing, to determine if the petitioner has established facts that are sufficient or alleged facts that are sufficient to establish standing. It is not here. The court has further reviewed the proposed findings, fact, conclusions of law and order that was prepared by Island County. The court is comfortable with portions of this order as memorializing its decision. And if somebody from the county has a version of that in front of them, looking at page 8, the court is not comfortable and is not including paragraphs 32, 33, or 34. The court proposes to add to 35 the following: that the project site adjoins Highway 20 and has its access on Morris Road, a county collector road. Petitioner declares as fact that he regularly uses the intersection of Morris Road and Highway 20 to get to his property. The ZCI was processed as a Type 2 application under ICC 16.19.140. Notice for Type 2 decisions shall be by publications and postings of the subject property. Under 1619.160B2, any person who requests notice of the decision on a Type 2 application entitled to receive it by a first-class mail. Under 1619.190B1, an administrative appeal of a Type 2 decision can be filed by any aggrieved person. Petitioner did not file an administrative appeal of the ZCI. That is the language that the court proposes to add to paragraph 35. The court proposes to replace paragraph 39 on page 9 with the following: the court has considered the declaration of the petitioner and his testimony at a prior phase of permit processing as regards this project as quoted in his response to the motion to dismiss, in determining whether he does in fact have standing as regards the particular issues raised in his petition. As described in paragraph 35 above, his failure to exhaust his administrative remedies precludes his challenge to the ZCI. As regards most of his claims to insufficiencies in particular aspects of the challenge project, water pollution, noise, and degradation of rural character, his claims are speculative and conjectural. They are not based on facts demonstrating that the events that he anticipates will occur, much less that they will immediately affect him, but rather demonstrate that he is affected in the same manner as the public at large. The court proposes to add as paragraph 39.5. As regards petitioner's issues about traffic, he asserts that additional traffic trips and congestion will occur, but petitioner does not contest the hearing examiner's findings that shelter guests would be screened in and then transferred from Oak Harbor at 6 p.m. each night and driven back there at 7 a.m. each morning on vans operated by applicant. The patrons aren't taking the bus or using the bus stop. The site is adjacent to State Route 20, which is a public highway. What the court proposes to do so that you can get an order entered. Do you have a form of order, Mr. Smiley, that with the court's proposed inserts, which the court can give you, at which you can, if you can pull it apart and just add them as additional pages, we can get something entered today.
Your Honor, could I suggest, given the length and clarity of the court's decision, that we put this in a typed Word format, and that we make the alterations. And if we can agree as to form with Mr. Power, we could present that by agreement, or we could renote it for presentation at a
Mr. Smiley, you'll do as, if that's what you want to do, I'm going to hand the work product over so that you can do with it what you will. So we are not trying to get an order entered today, and as it happens, I have people who've been waiting since 3 because I was simply unable, I got you folks started late, so I'm concluding you late. Mr. Smiley, anything else that I need to do in this matter today from your perspective?
No, Your Honor, you have made a verbal ruling. My suggestion is that we technically continue the initial hearing to the time for entry of the court's decision.
That works for me. Mr. Gustafson, anything else that you need?
Yes, Your Honor, I'd like to have the court note that in the declaration, we did ask for attorney's fees.
There is, the court is not, repeat, not awarding attorney's fees.
Yes.
Statutory attorney's fees to the prevailing party if they're provided, no basis for reasonable attorney's fees here. Mr. Power, anything else that you need from the court today?
Could I just ask the county if they would just to provide me with the documents of the court's notes for that order, so I can have a copy of those as well?
I'd be happy to, sir. We can scan these in and send these. It'll probably be
I appreciate that.
tomorrow or the next day. I'm trying to get away
There's no rush.
in the daylight.
Thank you, and I have the same issue. I brought people in because I'm trying to get them in and out while it's still daylight. Mr. Power, please excuse me. You said that was the one matter. Was there anything else that you need from the court?
Nothing else. Thank you very much.
Gentlemen, and everyone, this has been a pleasure. I appreciate the opportunity to work on the project and wish everybody happy holidays.
Thank you, Your Honor. You too.
You too.
Thank you, Mr. Power, as well. It's been a pleasure to speak with you.